Good morning, Your Honor. Can you hear me?
Yes, we can. Whenever you're ready, Mr. Cosden.
Thank you, Your Honor. Christopher Cosden, C-O-S-D-E-N, representing Rigoberto Ramirez, who is the appellant here and was, excuse me, the defendant in the court below. I would ask that the court allow me to reserve 5 minutes for rebuttal, please.
All right.
May it please the court. Your Honor, there were two problems with this case. Mr. Ramirez-Gonzalez was convicted of lewd act, honor in the presence of a child. He moved to withdraw his plea. That motion was denied in the trial court. In the trial court, there were two problems. One, the plea colloquy was insufficient. It did not meet the standard required in Padilla versus Kentucky and in Hernandez versus State by the Florida Supreme Court. In addition, the defendant was never provided the advice that was required, absolutely mandatory, by the U.S. Supreme Court in Padilla versus Kentucky and by the Florida Supreme Court in Hernandez. Now, the insufficiency of the plea colloquy is clear from the plea colloquy. If we look at page 66 of the record, we see that the defendant was asked, okay, do you understand if you are not a United States citizen that you could be subject to deportation? Answer, yes. Well, the defendant was not a United States citizen. And the question that was asked and answered in the plea colloquy was not sufficient to qualify the plea. Now, in Hernandez, and I'm on page 763 of Hernandez, the court held that the plea colloquy included Hernandez's affirmative response in the presence of his appointed counsel to the court's question, do you understand that if you are not an American citizen, the U.S. government could use these charges against you in deportation proceedings? Which was virtually the same as what happened here. The court held, because Padilla requires from counsel more than this type of equivocal warning, the court's warning could not have sufficiently removed the prejudice in this case. When the deportation consequences are truly clear, the United States Supreme Court in Padilla requires effective counsel to provide more than equivocal advice concerning those consequences. The Padilla court went on to hold the colloquy required by Rule 3.172 may refute a defendant's post-conviction claim that he has no knowledge that a plea could have possible immigration consequences. However, it cannot by itself refute a claim that he was unaware of presumptively mandatory consequences. Now, that's exactly what we have here. The consequences were mandatory. Now, the federal statutes that address that are quoted at length in the briefing. I'm certainly not going to read all of that, but deportation of a non-citizen is mandatory following conviction of sexual abuse of a minor under state law. And in United States versus Padilla-Reyes, Padilla-Reyes, the 11th Circuit held that a violation of Florida Statute 800.04, which is exactly what we have here, qualifies as sexual abuse of a minor in that context. In addition, in this case, the defendant was convicted of a crime involving moral turpitude under the federal statute, which would also mandate deportation. So, and the discretionary relief that can be applied in some cases is barred in this case, again, by federal statute. So we have a plea colloquy that was clearly insufficient as a matter of law. Now, the second problem with this case was insufficient advice that was provided by trial counsel. Trial counsel never answered defendant's questions about whether he would be subject to deportation. Again, from the statutes, it is eminently clear that deportation for a felony conviction of 800.04 is mandatory. There is simply no question from the statute, from the federal statutes involving immigration, and from the state and federal case law that deportation is mandatory. Now, counsel had an affirmative duty to so advise the defendant. In
Mr. Costin, let me ask you a question. There's also some talk in the record about the fact that this is a second-degree felony that a plea was entered into by the defendant, and he was looking at significant prison time had he not pled. And in fact, he had a pretty favorable plea deal, which only gave him probation. Isn't it also incumbent that you establish that he would have gone to trial but for this allegedly insufficient advice that he received from his attorney?
Yes, Your Honor, and he so testified very specifically at the hearing on the motion to withdraw his plea. I don't know how I could establish that more clearly than for him to say it, and he did.
Well, having said in a number of 3850s as a trial judge, it's pretty much the norm that he's going to say at this point, I would have gone to trial, but there's testimony in the record that that what made this plea deal, what resulted in the consummation of the plea deal was the fact that he became aware upon watching the interview that the evidence against him was strong, and that was sort of the sticking point. So help me out with that.
Well, Your Honor, the testimony to which the court refers, I think starts at page 330 of the record. And if we look at that testimony, what we see, I'm sorry, I miscited the record. This starts at page 310 of the record. And it starts off with the testimony of trial counsel to the effect that defendant did not want to enter a plea because he was concerned about possible deportation. And then goes on to how trial counsel was able to resolve the case. And then trial counsel mentions the issue that the court just raised. And the testimony was that the case against him by trial counsel was that the case against the defendant was fairly damning. But trial counsel did not address anything that would support the notion that counsel or that the defendant would not have gone to trial. That's a double negative. Let me see if I can say it a little bit better. There is nothing in the testimony by trial counsel to the effect that the defendant knew he was going to get deported and entered the plea anyway. That's simply not there. Trial counsel never said that. That was, of course, the error in the order denying the motion to withdraw a plea. The trial court ruled that defendant did not meet the requirements of the sixth prong of Cano v. State, and there was not testimony in the record by trial counsel or by anybody else to support that. So at any rate, we have mandatory deportation under the federal statutes. Now, when deportation is mandatory, advice from trial counsel to that effect is also mandatory. In Padilla versus Kentucky, the U.S. Supreme Court held, when deportation consequence is truly clear, as it was in this case, the duty to give correct advice is equally clear. The rule in Cano is about as clear as anything that ever comes down from the U.S. Supreme Court. We now hold that counsel must inform her client whether his plea carries a risk of deportation. Here, there was not just a risk of deportation, deportation was mandatory. There was a good deal of testimony in the trial court about whether or not deportation had been discussed. Well, deportation had been discussed. Deportation was discussed in the context of the defendant asking his trial counsel whether or not he would be deported. And trial counsel repeatedly answered that question, I don't know. Under the rule in Padilla, that is insufficient. I don't know doesn't work. The Padilla court told us that trial counsel must, not may, not should, but must advise a client that deportation is likely or mandatory. The day before the defendant entered his plea, there was an exchange of text messages between the defendant and trial counsel. This is at page 241 of the record. There is a photograph, it's not a terribly good photograph, of a cell phone. And the defendant, the evening before the plea, this was after 8 in the evening, was still asking his counsel whether he would be deported. And counsel is still not answering the question. Now, counsel's testimony was that he had deferred the question to a different attorney. He had given the defendant the name of an immigration attorney, and the defendant could consult the immigration attorney. But that's not what the rule in Padilla requires. The rule in Padilla is absolutely clear. Counsel must inform her client whether his plea carries a risk of deportation. Not counsel must seek other advice. Counsel must inform his client. That did not happen in this case. Therefore, the trial court erred by not allowing the defendant to withdraw his plea. If there are no other questions, I would like to reserve the remainder of my time for rebuttal, please.
All right. You timed that very well. All right, Mr. Edmondson.
Thank you. Good morning, Your Honors. Ryan Edmiston, representing the appellee, the state of Florida. I'd like to give a very, very brief recitation of kind of the procedural background of this case, because it'll help address appellant's claims here. As Judge Black initially indicated, the appellant was initially charged with 2 secondary felonies for lewd and lascivious conduct and lewd and lascivious battery, and he was facing a potential exposure of up to 30 years imprisonment if he were to be convicted on both those counts. On the morning of trial, he entered into a negotiated plea agreement with the state. As a result, the state null pros count 2, an appellant pled solely to count 1 for an entirely non-incarcerative incarcerative sentence of 10 years probation. Apparently, shortly thereafter, appellant was picked up by custom and immigration enforcement agents, and deportation proceedings were initiated. He then filed his motion for post-conviction relief pursuant to Rule 3.850, essentially alleging that his plea was involuntary because he did not receive any advice whatsoever in any way regarding possible deportation if he were to accept a plea deal. The court found that claim to be facially sufficient, granted appellant an evidentiary hearing, heard the evidence and testimony presented, and ultimately determined that appellant failed to establish the prejudice prong of the Strickland and Hill analysis, that being that he actually would have declined the plea offer and proceeded to trial if he were to have been differently advised. To cut right to the chase, this is not a case where appellant's claims were summarily denied solely based on the plea form or the record of the plea colloquy. Instead, appellant was given the opportunity at an evidentiary hearing to present evidence and testimony in support of his allegations, and the court simply found him not to be credible. The court found that his claims in his motion and his trial testimony were contradictory. They found that his allegation that possible deportation was the most pressing issue for him, yet he entered into a plea having had none of his questions answered and having received absolutely no advice, to be, quote, logically inconsistent, and simply found that the other evidence and testimony presented at that hearing refuted appellant's claims. What the court did find compelling was the testimony of trial counsel, Mr. McCreary, and the assistant state attorney, Ms. Garza, who testified that, again, contrary to appellant's allegations, that counsel was aware that appellant was not a U.S. citizen, that they discussed potential immigration consequences if he were to be convicted on multiple occasions, that appellant was well aware of the high likelihood of deportation if he were to be convicted, and that, in fact, that fear and knowledge of deportation had, in essence, stalled the resolution of the case. A review of the record reveals that this case was set for trial numerous times and was continued each time up until the point where it was ultimately resolved in the instant plea. As opposing counsel indicated, the trial counsel advised appellant to consult with an immigration attorney regarding potential deportation. He provided him contact information, and appellant declined that advice, stating that he had already obtained his own immigration attorney. And again, the court importantly noted that appellant ultimately resigned to accepting a plea offer in this case once he realized the strength of the state's case against him, specifically his own video recorded confession to law enforcement. Again, trial counsel testified that he, in fact, did review the plea form with appellant prior to him entering the plea. They specifically discussed the deportation provisions contained within. Appellant acknowledged that he understood those deportation provisions and confirmed that he still wanted to move forward with the plea regardless. The court also found that appellant provided no testimony or evidence regarding any potential defense that he would have put on if he were to have proceeded to trial. And again, the court noted the vast discrepancy between his potential sentence, had he been convicted on both counts, again, 30 years imprisonment potentially, and the sentence he actually received as a result of the plea, entirely non-incarcerative, 10 years probation. Again, this is not a case where the trial court summarily denied these claims based solely on a potentially deficient plea colloquy or only on the plea form. Instead, appellant was given the opportunity to present his case, present evidence and testimony in support of his allegations, and the court simply found him not to be believable. As this court is well aware, the trial court's factual determinations and determinations of credibility derived from an evidentiary hearing, and I believe the case law, it's from their superior vantage point, are given deference when it's supported by the evidence. The state would assert in this case that the court relied on competent substantial evidence when it determined that appellant's claims were not credible and refuted by the other reliable evidence and testimony presented, and that the court correctly applied those factual determinations to the law when it found that appellant failed to meet the prejudice prong under that Strickland and Hill analysis, that he actually would have proceeded to trial and declined the plea offer had he been differently advised as alleged. If there are no questions, I was going to keep it very short and brief here, and would respectfully request that the court affirm trial court's denial of appellant's motion for post-conviction relief, again, as the court's findings were supported by competent substantial evidence, and its application of those factual findings to the law was correct in this case. Thank you.
Okay, well, thank you, sir, and we never object to keeping it brief. Thank you so much. Mr. Cosden, you have 5 minutes, sir.
Thank you, Your Honor. Counsel made reference to a high likelihood of deportation. That's not what the federal law requires under this sort of a conviction. Deportation is mandatory, both because the crime is an aggravated felony and because it is a crime of moral turpitude. Again, that's addressed in the briefing. I'm not going to go through it again now, no need for that. The counsel made reference to the trial court's ruling, but the trial court's ruling must be supported by competent substantial evidence. Here, it was not. Specifically, the problem with the trial court's ruling had to do with the finding by the trial court that the court finds, I'm on page 204 of the record here, the court finds that defendant's motion should be denied for failing to prove prong 6 of Cano. Cano, of course, being Cano v. State, 112 Southern 3rd at 646 from the 4th District in 2013. Now, the court found specifically, again on page 204, that trial counsel's testimony, the defendant in fact believed he would be deported. There is simply no basis, nothing in the record to support that finding. Trial court, the testimony in the trial court, which is relevant, is found at page 310 to 313 on the record. This was the testimony to which I made reference a bit ago in response to Judge Black's question. There is nothing there. If the And again, I'm not going to try to read that testimony to the court, but there is nothing there that would support a finding that defendant in fact believed that he would, and the word would in the order is italicized for emphasis, that he would be deported. There is absolutely nothing to support that finding of fact. So that finding of fact becomes error. It's not supported by the record. Counsel did not so testify. The defendant testified at some length that he did not get a clear answer to his questions. Yes, there had been discussion about potential deportation, but discussion is not what the law requires. What the law requires, again, set out in Padilla, is clear advice, not optional, must. Therefore, I would ask that this court reverse the trial court's ruling that defendant should not be allowed to withdraw his plea and remand this case to the trial court for further proceedings, including withdrawal of plea.
All right, thank you. Thank you
Thank you.
both.
Thank you, Your Honors.
Our next case this morning is Alcorn v. Alcorn.
How do I get out of here?